Hi, this is Lisa DeMonte from MyLegal.com, and we're here in Washington, D.C. at the Ronald Reagan Building for the second day of the Masters Conference. And with me this afternoon are Sharon Nelson and John Simic from Sensei Enterprises. Good afternoon.
Good afternoon, Lisa.
Sharon and John just served on two panels here at the Masters Conference. The first, Get a Grip on Social Media in the Workplace, a case study analysis, and second, Social Media and Ethical Quagmires. For those of you that don't know, Sharon is a practicing attorney in the Washington, D.C. area and is an expert in the area of e-discovery and is also the president of Sensei Enterprises. John is a nationally known testifying expert in the area of computer forensics and is an NCASE certified examiner. Sharon, we talked so much this afternoon about a social media plan. What comprises a good social media plan, and how do companies and law firms enforce it?
Well, I think you have to gather together a lot of players. Sometimes it's just legal that does it, or sometimes it's just HR. You need a lot of people because they have a lot of different interests. And then you have to put together a plan that makes sense for the company. I think prohibiting social media usage does not make sense. What you have to figure out is how you want the plan to work and what's going to be good for the company. And most importantly, you need to train your people. There's an excellent, on the internet, there's an excellent social media policy that Coca-Cola has put out there. And if you don't want to reinvent the wheel, I always suggest to folks that they take a look at that. There are other ones that are also posted on the internet so that they could take a look. Enforcement is just something where you've got to monitor one way or another, and in compliance with your state laws, of course, but you've got to occasionally monitor what's going on. Some companies will tell you, and Coca-Cola is one of them, and Sprint is another, that employees are very happy to turn each other in, and so that works for you. But we also believe in episodic monitoring, not to poke your nose into people's business all the time, but episodic monitoring can tell you a lot about social media. And then if you're having a problem, then you do need to enforce the policy.
Sharon, of course, today we talked about ethical issues that lawyers should keep in mind as they begin to get involved in social media. Can you give some lawyers some of your favorite or best practices and tips and techniques?
Well, they certainly need to be mindful of all their ethical duties, so they certainly need to be competent. If they're going to be in the area, they need to understand the ethical rules that apply, particularly the rules of advertising, because many of them are there really to nurture new business, as they should be. They need to be mindful of the rule against deceit, so they need to make sure that they are transparent and honest in all that they do. They need to be aware that if they're going to use recommendations, for instance on LinkedIn, that their state bar may not allow them to have recommendations that contain claims that cannot be substantiated. So they need to go through the ethics rules pretty thoroughly and make sure that they're not doing something stupid, however well-intentioned they may be.
John, let's turn to you for just a moment, sort of a segue from Sharon's comments here. We were talking about privacy issues, and I think you had everyone in the room standing up on in their seats when you were mentioning some of the privacy issues on Facebook and things that we perhaps were not aware of. Can you expound upon that a little bit?
Sure. Facebook is, well, they're the 800-pound gorilla of social media. They've got over 500 million users that are out there. Their terms of service, they can make changes and reset security settings, etc. So you may have set securities groups, as an example, and locked off certain areas of your Facebook wall, as an example, but yet 2 weeks later, you go back and it's all been reset because they've changed some procedure. They've now added, let's say, some third-party access to data, and as a result of doing that, they've cleared all those things. So you need to go in there and keep rechecking those settings. An interesting statistic: Facebook is really only 5 years old, but if you look at the amount of information that is by default publicly available. In other words, the user, when they first log in, they set up an account, what information can you typically see? That would be like your name, maybe your picture or whatever. As time has gone on, as Facebook has grown, and it's interesting to see a graphical of this in a pie chart, you see more and more information that is available by default to the internet. It's not restricted to the Facebook community any longer, but it's more publicly available, and it's pretty scary if you see those charts.
It's very scary indeed, and I think one of your colleagues here on the panel mentioned it's a really good idea to Google yourself regularly to see what kind of
Yes,
content
definitely.
is out there. What are your recommendations in terms of how frequently perhaps you should be checking those Facebook privacy settings?
I say at least every 2 weeks.
Okay.
Maybe even more often. You know, certainly if you've received notification that they've added some new feature. Anytime they add a new feature, definitely go in and check that.
Good sage advice. Sharon, one last question. I think as we discussed today, the ABA in August had a ruling that perhaps gave some clarification as to when the attorney-client relationship is triggered. Can you talk a little bit more about that and when the relationship is in fact triggered online?
Well, the ruling came down, it's actually a formal opinion, and it came down in August of this year. It's ruling opinion 10-457, and it goes into great depth about how communications through your website, and I'm extracting this because I think it's going to be more than just the website. I think the logic you're going to see in this opinion is going to be applied to social media as well, because there's really no substantive difference. But basically what they're saying is that the ethical rules that apply to prospective clients may apply very quickly when somebody fills in a little box on your website and you've asked them to communicate with you. Well, if they're communicating substantive facts about their case, you are in a prospective client situation now, and so you've got to be very mindful of your ethical duties. It also suggests in that opinion that you need to be very careful to have a disclaimer and to say that this is not being given as legal advice, there's no attorney-client relationship, and this is no substitute for legal advice. So it's asking really a very high burden of care on the part of the attorney.
Sharon, John, thank you both for joining us this afternoon, and I'm also excited to share with our listeners that the two of you will be speakers at the MyLegal.com sponsored conference, The Case for Social Media, Managing Your Online Presence to Build Your Law Practice, on October 21st at Georgetown University Hotel and Conference Center. You're going to be talking about many of these same ethical considerations and liability issues for lawyers. So again, thank you both for joining us this afternoon.
Thank you,
Thank you.
Lisa.